or firearm that was subject to that under some court order. An arrangement was made whereby the defendants would simply pay a sum, usually between $200 to $500, directly to the sheriff. The defendant would then take home the gun or vehicle and the forfeiture would go away. The next thing that made this kind of conduct most despicable was the sheriff and the county attorney were found to be acting together when they bought firearms and motor vehicles for the county attorney from the drug fund. So these individuals were funneling this money into the drug fund, and then they were taking it out for these items. The usual procedures for that, of course, would be a system of taxation where funds are put into the hands of the county Board of Supervisors who could buy these things, or they could do it by bidding or other processes. But in any way they would do it, it would be in the view of public scrutiny. In this case, these individuals were doing this, just the county attorney and the sheriff on their own. Perhaps the most blatant example of what I'm referring to was the sheriff's purchase of a Seiko. I never heard of a Seiko till I heard of this case, but a Seiko rifle that cost $2,554, which was apparently purchased for the benefit of the county attorney. It's just a little sidelight, but I understand in order to use this rifle, you really need a sight that costs just as much as the gun did. So they were talking about $5,000 before they ever got that rifle operational. This rifle was, instead of being, and it was true that no one knew about this rifle except the county attorney and the sheriff. The sniper, who apparently would be the person that would use the rifle, knew nothing about it. This firearm and 15 others that the county attorney had out of the sheriff's office was returned to the county sheriff and to the county sheriff's office. The Seiko rifle went to the sheriff's house, and the rest of the items went back to the sheriff's office. And there's 15 firearms that the county attorney had went back the day after Clark Kaufman's story in the Des Moines Register. I like to say in the middle of the night, but I guess it was only 8 or 9 o'clock at night. But why you couldn't carry him back in the daytime would kind of raise suspicion. While both defendants contended the purchases were necessary for safety of the sheriff's office, the judge just didn't see it that way. Judge Hutchinson, in his decision, made it clear he could not see any rational reason for this kind of conduct by either officer. There were many other items of misconduct that were alleged and shown at the trial. At the end of the trial, or actually 10 days later, the judge, in 2 very well-written opinions, found both parties had been guilty of misconduct and removed them from office. Chapter 66 has not been used much in the past, and as I indicated, has been very little used. The case law decision under it, which we had to use to be guided by, we and the judge, pretty much had protected and very rarely, I think I counted them at one time, I don't remember the number, but I think of cases that were appealed to the Supreme Court, and this was used much more in the past than it has been in recent years. Like I said, it had been at least 30 years since there had been a case. But in the cases in the past, most of the decisions on appeal were favorable to the defendant office holders. So this was a very heavy burden that was undertaken here for the removal of these folks. One cannot say enough for what the petitioners did. They put their name on the line, they put their money on the line. I was very proud to represent them. Uh, there was no polls taken locally, so I can only say what I feel from observation was the public was very much behind us. There was, as there always is in those kinds of things, there was some dissent, but I think that it was very successful. I mentioned that this came up. I guess I really didn't state as I intended to earlier that one might think that a board of supervisors would get involved in this. If you're familiar with local government, we have a board of supervisors. In my judgment, they're the only political, really truly political body we have. I get on my soapbox. I don't think that we should be electing all these people, but that's beside the point. But I think the County Board of Supervisors, as a policy-making body in the county, should have some authority over these people, but they have none. I think, however, they would have had a moral persuasion authority, and they sat by very much, I think, intimidated by these two individuals, and more than anything, probably by the county attorney. I think had they used their persuasion, I felt all along that if these folks come forward, I think we've all observed in observing people that get in trouble in politics. The best way to deal with your problems in politics when you're in trouble is to be honest about them and to come forward and say, whoops, I made mistakes, but we're going to correct them. Everything's going to be transparent. You're going to see everything that happened, and you won't have anything to question my integrity after this. I think if either of those folks would have done that, this case would have gone away. But it did not. People like my clients had it. I think it was a, excuse me, a very common feeling within the community that every week, not just the Des Moines Register, but all the newspapers in the state were saying things about our community, and we didn't like it. And these people took the law in their hands in the only way they could, and brought this petition that was successful. And I can't say enough for them. Again, I can't say enough for Clark Kaufman and the Des Moines Register on this either. Thank you.
Yes, I'm Arlen Nichols, and I was a co-plaintiff with Mark Gannon and the Citizens for Open Government here in Ames, Bill Kunert, and I'm going to be very brief. And I think I don't know whether we're fortunate or not to be in the Memorial Union that used to house an organization that forgot all about freedom. Now, we went to court for one reason, and that was to open the records at Iowa State. I didn't do that much. I knew the attorney who was my next door neighbor in Chicago, and I introduced Bill and Mark to him, and I want to say that we were successful in the Iowa Supreme Court unanimously. I've read in the paper where the foundation here has said that they're changing their way of doing business. Yesterday we discussed one thing. We said that it's funny, we thought the Iowa Supreme Court changed their way of doing business. Again, thank everyone here. I want to thank everyone here from Ames, the people from Atlantic, the students from Iowa State, and I'll turn it over to Mark Gannon, who really put the work collar on, along with Bill Kunerth, and I was just kind of a rider. Mark?
Well, thank you. Yeah, this has been even though Arlen and I have been kind of on the front line and in the papers, this has been an issue there's been a lot of people behind this. I thought if we started counting names, there are 30 or 40 people at least have been instrumental in this process. My involvement got started when I used to be the land manager at the College of Ag at Iowa State, and I was taken into the dean's office in December of 1996 to tell about a gift that was given to Iowa State University, given to the ISU Ag Foundation. And people are going to get confused with all the names, but don't. It's different than the foundation, but not that much different. And we're told that this money was going to be used for the animal science program. He explained that he didn't know who the lady was. It was just kind of a mystery. She gave her entire estate to the university, but that President Jischke had decided that money was going to be used in for the animal science, the intensive livestock building, and so that's just kind of the way it was. I spent the next month or so getting ready to manage her farm, figuring out where the money was, working with the money. Part of the money was already in the foundation. As it turns out, I was kind of foolish in the fact that I was trying to figure out who she was. To make a long story short, when we finally got the records of Marie Powers after several years, turns out that they knew who she was within 2 weeks after she died in December of Christmas, right before Christmas Eve 1995. There was memos in the file. John Pesic, who was the head of agronomy, had written Dean Topol and told him who she was, what she wanted. She had met with Neil Harrell years ago talking about what to do with her farm. That was in the file at the foundation, even though a year later, when I was as the manager of the Ag Foundation and were the title holder of the property, we found out, or I found out as a manager almost a year after she died, that we had this gift. And that was after the foundation and the university had gone to the court to get her will changed, to get the right to sell her farm. Said that she didn't have any buildings to maintain. One of her wills, two of her things she wanted to maintain her buildings, and she wanted her farm not to be sold. Well, they went to court and got both of those taken care of prior to the Ag Foundation board knowing much about it. The president of the Ag Foundation didn't know about it till he had to sign the an agreement coming out of the court. And all that was done behind the scenes by the university and the ISU Foundation people at the time. But anyway, so while I was the land manager at the College of Ag, we kind of held that farm in reserve with the idea that maybe they would raise enough money for the intensive livestock building, and then I left. I got kind of frustrated with that situation and some others, and I left between 1999 and 2000, and about December I met one of the board members, a guy from Clarion, who I was instrumental in putting on the board, and was talking about this Marie Powers thing, and he said, we're selling the farm, and I said, you are? And he says, yeah, and he said, well, we had to, and I says, why'd you have to? And he said, well, they said at the meeting that we had to. And I said, you didn't have to sell that farm. And I said, what are you going to do with the money? And he said, well, we're going to put it in the intensive livestock building. And I said, well, why are we going to do that? And he said, well, they apparently need it. And I said, well, we got a board, it's in the board minutes when I was still there that Dean Topol said that we had already raised all the money for the intensive livestock building and it was already funded. And he said, well, I didn't understand that. So he was kind of new on the board. He kind of came in midstream, so he went back to some board meetings and I guess caused kind of a ruckus and kind of raised these questions. And And I went to the newest dean at the time, and within probably a couple weeks after hearing that they were going to sell the farm, and just trying to explain to him what she wanted, what they were doing, and he wasn't really interested. In fact, he basically told me that I was sticking my nose where I don't belong, and so that got me started. At the time, I knew what Bill Cooner and some of his group of curmudgeons were doing, and there's a few of them in here right now. So I went to Bill and I said, Bill, I think here's a story that may help you with your openness with the university and the foundation. You know, I think they've been working for years trying to challenge some of the openness at the university, and I knew the facts behind that case. You know, the first meeting I ever had with Mrs. Powers' attorney, or phone conversation, not too long after meeting with the dean, the first time I heard about the property, his first words out of his mouth was, "What you're doing with that money is wrong." And I said, "Why is that?" And he says, "Because she would have never put it in she wanted that for seed science people, and putting that in an animal science program she would never have agreed to that." And so that got me started trying to protect it within the Ag Foundation, and after I left, I couldn't have done anything about it anyway at that point in time. I was just an employee. I wasn't one of the board members. But I guess then we started getting together, and Bill saw the merit in the case. I went to the Ames Tribune. They wouldn't have it. They just couldn't see the merit in it. They didn't think it was worth the trouble to drive up to Fort Dodge and research the case. So we went to the Register, and Frank Santiago down at the Register bought into it, convinced his editors to do it. So that was the start of the Marie Powers case, which that's what brought me into this whole open records issue. And in the meantime, Neil Harrell and Bill had a group of people that we ended up calling the Citizens for Open Government, that were trying to get openness at the university, and so I kind of joined into that group, and in that time frame, you know, we were negotiating with the foundation, or people were talking to the foundation, trying to get more openness through the foundation, and you'd get a little bit here and a little bit there, but it's more policy things which they could change, you know, in a moment's notice. So I guess they came out with a new open records policy I didn't think was good enough. So well, I guess I'm getting things out of order, but I guess in the meantime, we heard about a guy in Des Moines that was pretty crotchety, and he was wanting to take some people to task too. So I said at the meeting one day, I said, well, who is he? I mean, you know, let's find out who this guy is. And I think he kind of scared, I mean, just the idea, some of the group were more vocal than others, and I think some of them were kind of the idea, well, you know, I don't know if we want to push this too hard, you know, but so I made a point to, and I think, I'm trying to remember all the circumstances, but Bill and I, we got together and met Arlen and realized that he was passionate about it. And the big key that Arlen talks about, and I do too, is that we found a law firm, an attorney that was willing to take it on and knew the merits of the case, felt good about it. You know, to me, there's about 5 or 6 people that are instrumental in this whole deal, and people want to look at Arlen and I think those were necessary too, but you know, it couldn't have been done without Bill Cooner. It couldn't have been done without Tom Hansen. Frank Santiago was, you know, he takes as much credit as anything. You know, guys like Neil Harrell sitting in here gave me the confidence to feel that we really had something we could push for. You know, it took a while, and in this town, you just have a hard time fighting university, and it's not real popular. Most of our supporters were university supporters. They were retired faculty, they were associate deans, Most of them retired. Most people that are on the staff do not want to take that risk. I mean, they worked under a president that would, I don't know whether you say retaliate, but I mean, it was a tough situation, and it's not real popular to do that, you know, in Ames, but it worked out, and we felt we had the law on our side, and I don't know. That's probably about it. But you know, it's been a long process, and again, after meeting with Tom Hansen, we didn't realize what we could do. You know, I mean, I didn't know what we could do under the law, and he told us how we could do it, and we raised some money to try and fund the process, but it was a drop in the bucket compared to what it cost really probably to do it. But now that he won, you know, I mean, he can get, you know, he can get paid more for his costs. But
I'd like to add just one other thing, that the National Society for Professional Journalists also kicked in, and really that was the only media support we had. We asked several of the newspapers and television areas for monies, but like our attorney said, that's a poor place to ask for money. Maybe I guess that's it.
I want to thank y'all for telling your stories. I'm sure there are questions. Surprisingly, one from Bill Cooner.
I just want to say there were a lot of people involved in this effort.
oh yeah,
But of all those people, only 2 people that got stuff through the university. The rest of us were very reluctant to
Yeah.
become parties to this too. And 2 guys did that.
yeah. I
Were
appreciate-
in no place.
Well, we appreciate that, Bill, coming from you.
And the other thing that I think gets lost in this is that I think as much as anything is that we were really asking for the Board of Regents to do their job. And that isn't brought up in these articles or anything else, but that's the big thing. That's what we had to that's where the statutes were, that was their responsibility to oversee it. They're the ones that set up these foundations. They were given the authority to set up the foundations. And that's a state function, and we're still going to be on that case. I mean, the whole story kind of revolves around opening up the foundation, but as much as anything is getting the Board of Regents to do their job. And believe me, if any system's broken in Iowa, it's the Regents system, and maybe we can keep working on that.
That gentleman there, John.
Yes, if you're successful in getting the records open, how far back in the records could one then go as far?
We asked until 1995. However, the attorney did say that since the payroll was being paid by the state of Iowa, and all of the employees were state employees, he thought that the very direction of funds would make those records available too. Of course, I think they can hide behind a lot of those records that are 10 years old, but that's the legal opinion we got yesterday.
95.
Well,
295, that's what we requested.
that's what we requested, but there's really no reason to think you can't go back to the beginning, because we based a lot of it on how the foundations were set up originally. So if they're open till 95, why would they not be open before that?
That's interesting.
You spoke about the foundation in a way that suggested that maybe there's more than one foundation here? Like, is there a college foundation and then an agricultural?
Well, there was an ag foundation that was set up in the 1930s by a banker that donated 10 farms and put $100,000 into a fund that was used it was kind of the beginning of the experimental farms. And then and that was called the ISU Ag Foundation. That's why part of this is confusing, because I think when the original call came down to the university about this gift to the Ag Foundation, the call was directed over to the ISU Foundation. And so they investigated this and tried to claim it as their own. And but yeah, there's about, well, all the affiliates have to file a report to the Board of Regents every year, and Iowa State's got 9 or 10. Now there isn't, I wouldn't necessarily call them foundations. There's ISU Research Foundation, there's the 4-H Foundation, there's the Ag Foundation, there's quite a few really.
Well, then is it correct that it was the Ag Foundation that did all this improper procedure? And not
Partly,
the
but
general?
the ISU Foundation, Murray Blackwelder was the one that was up there to Marie Powers' attorney within a week and told, we've got the notes from her attorney saying that he said that he was the president of the Ag Foundation and wanted to change some of the will. He went up there, when he said, prove that to me, he said, well, the Ag Foundation's been rolled into the ISU Foundation, and when the attorney said, prove that to me, then that's when they went to court.
I think they said put it in writing, and he wouldn't put it in writing.
Yeah. So there's nothing the university, the foundation doesn't do without having the university involved.
As to, if they don't get to the microphone, if we could repeat the question so everybody could
Oh,
hear.
all right,
All right.
okay.
Yeah.
Well, I wonder if someone could explain the difference between a proposition like they have in California and a petition, okay? And then
We'll
the
pass
second
that on to
thing,
the attorney.
the second part, because apparently you cannot have a proposition in Iowa, okay? And put it on the ballot. Now, the other thing is the Athletic Department Foundation part of the ISU Foundation, and will they make their records available?
I don't think they have a separate foundation. They have a fund.
Is it
Yeah.
I
Well,
think
I would think
State
that to
law
be,
that makes the athletic council.
I can't answer the questions about the proposition. We'll let Ron answer that, but I can tell you this about the foundations. Every record is public unless the foundation can say it's confidential. All of the records of all of the foundation. That was the ruling of the Iowa Supreme Court.
see, and that's one of the things that really got us stirred up when we got the records of the Marie Powers Foundation, or money, is that when it was, we felt improperly gifted to the intensive livestock building, it turns out that it wasn't all put there. Part of it went to Brenton Center, part of it went to Ryman Gardens, part of it went to remodel the offices in Curtis Hall. Now that was eventually supposedly put back. I don't have the records of that, but that was we didn't even know that until we got the records of the egg.
And that was also repaid to the foundation.
So I guess that's part of my point in opening up the records of the foundation is, you know, even if they say it's going somewhere, it can go somewhere and it can be reversed, you know. They can show you a receipt that says it went somewhere, but unless you have the whole record, you don't have anything.
As best that I can respond, as I understand the propositions in other states, at least in Nebraska, which is closest to me out in the western part of the state, Nebraska, they petitioned to have various propositions put on their ballot. Many of them are constitutional provisions, and then some of them are statutory things, like I read the Omaha World Herald every noon, and they're always talking about petitions for to establish gambling in Iowa or in Nebraska. The citizens over there are sick of their money going over into Iowa, but they can't seem to get the voters to go that way. But anyway, that sort of thing is done by petition. And of course, the other state that come to mind where they operate with propositions, which again I think are all put on by petition, is California. And I was observing to one of my fellows on the way in that California has passed laws which I think attempt to regulate economics, or maybe that's not quite the way to say it, but to establish new rules of economics. Like, I remember they passed a proposition a few years ago that said insurance rates on automobiles had to come down. I never quite figured out how they could enforce that, but as I understand, they did somehow out there.
Iowa also has provisions depending on what type of petition you're trying to put forward on whether or not it can be on a general election or if it has to be its own special election, which prohibits some things from ever making it to the voters.
Both of those cases involve members of the bar. What can you say about what the Supreme Court has done in the two cases? Because in both instances, it really represented a breakdown of ethics on the part of the lawyers involved.
Yeah, to you.
Right. Yeah. I didn't quite understand your question, Neil.
We couldn't hear you.
Was both cases involved members of the bar. What has the Supreme Court done? Because in both instances, the problem was really at the bottom, the breakdown of ethics on the part of the lawyers involved. In the one case, pushing through the sale of a farm against the clear wishes of the testator and against good sense, actually, once you look at the records. In the other case, the county attorney, who I think by any stretch of imagination was violating ethics. Iowa has a reputation of being a very tough state when it comes to those who hold a license to practice.
Well, as you may be familiar, the Supreme Court, if I understand the rules on the Ethics Board, that's a group of lawyers that first hear the ethics complaints. In Iowa, if you're anything but a county attorney and the complaint is about you as a practicing lawyer, it goes to a commission member. I think there's 5 or 6 panels at a time, and I'm not sure whether it consists of 5 or 7 individuals. There's 4 of those are lawyers, and I think the other 3 are laymen. But the exception to that was at the time this occurred, as far as the county attorney was concerned, was the county attorneys had their own group of ethics board, and it's my understanding that that's now been changed. And so now the same body that hears all the other ethics complaints will hear that. In this thing and what's happened lately with respect to the county attorneys and the production of information, I always have the feeling that it looks to me like they're out to protect the prosecutors and the law enforcement people. If you ever notice that the grand jury is hardly ever used in the state of Iowa except to investigate a police officer or somebody of that nature, and we had one out in western Iowa recently where the county attorney made the comment when they failed to enter a bill or failed to indict the individual that had shot somebody in his home. The story was they were out to recover this guy's pistol or another police officer's pistol, which this guy had walked away with somehow. I don't remember the details, but the police officer went to his home. Another police officer went to his home to check into that. He went through they broke in. They didn't use any kind of siren system or any microphones to tell them to come to the door. They went in, and apparently the guy looked up and maybe he had something in his hand. He was shot dead. The grand jury was called, and the grand jury entered no bill, which means there wasn't any indictment issued. Those seem to be the only kind of cases that the grand jury has ever used, and I've never dealt with that as a practitioner. I'm not in the criminal area. In fact, this case that I was involved in was completely out of my bailiwick. But if you observe, it always seems like they use the grand jury as a way to clear the police officers. And I've wondered about close cases where they indict some young individual for some freak accident that happened, or where a county attorney's information is issued. What would have happened if that was given to a grand jury? But those individuals aren't given that privilege like the police officers. And I guess my feeling is, and I'm quite concerned, and I back the Des Moines Register and everything they do in trying to get out information from DCI investigations and other things. In this case that I was involved in, there was a DCI investigation. The Attorney General's office has said they would help me. When I asked them for the help, the individual who later handled the grand jury investigation out in Cass County told me, he said, if you guys bring these cases, you got to figure out how you're going to prove them yourself. Now, I was the prosecutor that stood in the shoes of the county attorney, but the Attorney General's office wasn't going to help me. They had a DCI report they wouldn't provide to me. I told him I was going to subpoena it. He said, go ahead, we'll meet you in court. I had like 6 days to prepare for trial. I didn't have time to fool with him. But that indicates to me an attitude that needs to be changed. The Des Moines Register and I think Quad City Times both criticized the Attorney General for not pursuing this case in Cass County. I concur in that 100%. I wrote the Attorney General a letter in criticism of their failure to cooperate with me in that matter. And the DCI report, the Des Moines Register asked for that, and I don't think this has been public knowledge, but I'm sure the DCI was asked by the Des Moines Register for a copy of that report and the investigation that was done in Cass County, and they denied I don't know whether that was through the Attorney General's office or the DCI itself, but they refused to open those records. It's been pointed out to me, and I've read the case, I can't cite it right now, but there's an Iowa Supreme Court case where a problem much like this was a big news story, and lots of things that went on with it, and the Supreme Court held that that report should be produced. It gets down to the same problem that the people in Cass County had. It costs money to protect your rights, to get what you're really entitled to. That's not right. I think I support very much the journalists' effort to open up public records. I've found that a huge problem. My work, in most part, in the past, as far as civil work, usually motor vehicle accidents and that sort of case, it's always been a battle to get public records in my experience, particularly if there was any criminal charge filed. This is despite, in my view, the fact that the people I've dealt with are just almost always terrific people. The police officers that I deal with, the highway patrolmen, the state auditors people in this investigation we dealt with on the county attorney and the sheriff, they were just fantastic. I thought excellent public servants and would be proud of them. But why then the people in the Attorney General's office and the law enforcement people themselves are always so reluctant to put out the hard work that they've done in the investigation just blows me away. I can't understand that. There's just no rational reason for it as far as I'm concerned.
Any more questions? Or I was going to put Clark on the spot if possible. I mean, Clark, could you speak to the recent audit that we just did and maybe answer Mr. Feldmauer's question on, I mean, the reluctance or what you found on why public officials are reluctant to open public records, and then speak about the audit that the register just, well, and other newspapers.
The audit?
The public records audit.
As far as the reluctance of the Attorney General's office, I'm kind of at a
Speak
loss
up.
to explain that myself.
Yeah, use the mic.
Oh, I'm sorry. I'll bring it to you. Oh, sorry.
Journalists are not used to public speaking, so I.
Back in the office. Yeah, as far as the Attorney General's reluctance to cooperate with a prosecutor in the Cass County case, that was amazing. I wasn't too surprised that they wouldn't cooperate with us in terms of making public the DCI report. But it does raise that question of what the criminal investigation actually showed, because since it went to the grand jury, we have no real insight as to what the investigators really found out. So that's that question. What was the other half of the question?
If you'd speak to the public records audit that was just finished and published, and as opposed to 5 years ago, and then I mean, this is the public open records and open meetings are not just for the press. Therefore, anyone who just came in. So you might, if you.
Well, yeah, that's right. What we tried to do in the public records audit was basically send people into police stations, into school district offices, city halls all around the state to find out how much access the average citizen might be able to get when they just asked to see certain types of records. And what we found was a similar pattern somewhat to what we found 5 years ago, which was a lot of reluctance in certain quarters to part with any kind of information, but it varies from one jurisdiction to the next. In some instances, people would be very cooperative, make all the information public. In others, reporters were running into situations where they were followed from the courthouse by law enforcement personnel. There were some kinds of intimidation tactics. One reporter at the Register just recently was kind of tossed out of the federal courthouse because they have some regulations there in terms of anybody who goes into the federal courthouse needs to show a government-issued picture ID. And that's even after you've passed through the metal detector. So theoretically, you wouldn't pose any kind of a threat to anyone, but you have to pass some other kind of undefined test before you can even enter the federal courthouse. So we fight those kinds of battles on a regular basis.
Clark, doesn't Chapter 22 say that if you walk into an office and if they hold the records, they have to make that record available?
Well, it does, but then you actually get down to that issue of what actually constitutes a public record as opposed to what constitutes a government record. Because there are these exemptions, a growing list of exemptions to the public records law, but even when it's in black and white, we ran into situations where you would have law enforcement personnel say, I don't care what the law says, we're not going to give you that record. So that's obviously discouraging when you're hearing that from either lawyers or police officers who are violating the very laws they're sworn to uphold.
Thank you.
I think that you'll find that where the First Amendment is a wonderful philosophical tool, but where it really cuts down to it is when you have open records and open meetings. And that's where you really find out whether it is a government of the people, by the people, for the people, because if the people can't get information that is theirs, the public, it is not these officials, it is the public's information. And if the public can't get that information, they can't be informed and educated and come in and help the officials make decisions about what they want. You know, I'm sorry, I'm getting on a soapbox, but I'd like to say one more thing and then I'll shut up. What would be nice to create would be First Amendment communities where you have public officials who are truly public servants. And when I talk about public servants, I'm talking about people who facilitate the public's wishes. And on top of that, you have a committed public that makes sure that the public officials know what their wishes are. And if you have, and instead of this, you know, give and take, and it's our records, it's your records, if there becomes a cooperation, then you've got a wonderful community and wonderful synergy going on. But that can't happen unless the public has the information it needs to help the officials make those decisions and make sure that they're educated and informed enough to make those wishes known, and you know, and that also fits in the budget. You know, and if they don't have the budget numbers, they can't figure that out. If they don't have the records, they don't know where the money is being spent and all that. I mean, and this is why this issue of open records and open meetings and the continuing tendency toward public officials to close, records and well, Polk County. What do we have? The rolling quorum. I mean, the audacity of the rolling quorum where the Board of Supervisors in two huge issues where they're trying to decide who is going to manage the Iowa Event Center in Des Moines, one issue, and the other issue is where they are trying to decide whether to increase gambling at Prairie Meadows. And you've got a Board of Supervisors, 5 people, quorum is 3, send 2 people in the meeting, the other 2 waiting out here. Then, what, a couple hours later, these 2 go in, these 2 come out. These 2 come out first. These 2 go in. And back and forth to where you don't have, there's no quorum, there's no open meeting. The audacity of those people. Thank you. That you cannot have a First Amendment community with public officials who have that view, that attitude. And I would vote them out.
If I could jump on a soapbox for a second. To go along with what you were saying about access when going in and asking for records, Ryan's not here, but I'll share his story because Ryan and I share a life. So, but anyway, when we tried to initiate this petition, Ryan went to City Hall and was asking around about how to go about the petition. And when he initially went in, he said, "Hi, I'm Ryan Dahl. I'm a student at Iowa State, blah, 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 blah," and asked his question. And after the third office he went to in City Hall, he introduced himself as, "Hi, I'm Ryan Dahl. I'm with a community group, and we have some concerns, and we'd like to file a petition." Well, and that lady just right off the bat knew that he was in the wrong building and sent him over to Nevada, to the courthouse. And when he got to Nevada, he said, "Hi, I'm Ryan Dahl. I'm a concerned community member," and boy, they knew right where to take him. So just for comparison, when he went back with the petition in Nevada, he went in and said, "Hi, I'm Ryan Dahl. I'm a student." Boy, they gave him the runaround again. And it's not exactly the same thing, but I think that that's something that, especially in Ames and Story County, is a real problem, is that students are viewed as almost, I'm going to go out on a limb and use the word second-class citizens, in that, you know, just because we don't own property or we aren't here for a long period of time, that we don't know what's going on, and that, you know, it's okay to push us aside. But on the same hand, as exposed in the Des Moines Register, our student government, and occasionally we use instant messenger during meetings. So I I might be the only one in the room that knows what I'm talking about, but I'll chuckle to myself.
Technology and open meetings.
Let me
David?
yeah, let me ask this question to the Cass County folks. I guess I got two questions. One, the two guys who've been thrown out of office, is there any potential for the Marion Berry factor to come back? Yeah. In other words, could they come back to office someday?
Well, legally,
As one participant, I'd say short answer, no. One of the other consequences, we recently had a board of supervisors election, and 2 of the 3 had opposition and were defeated.
So, what you were going to say too?
well, I think the short answer is exactly what he said. Legally, it's possible. I think I think there are still some pending ethics issues as far as the county attorney are concerned, and I don't know that those have been resolved by the authorities, and what could happen if he were disqualified as an attorney. Then of course he couldn't be running for county attorney, but otherwise I think if they both wanted to come back and run for election, they could.
Do you see these folks around town, and how do they treat you? Or how do you look each other in the eye and still be friends and neighbors, or do you just have to sort of walk parallel lives?
Again, county attorney over the east part of the state.
I've not had occasion to visit them. The sheriff still lives in the county. If I'd seen him, I'd be glad to visit with him. He was helpful to me in some efforts several years ago. I had coffee yesterday morning with the county attorney's uncle. We had a good conversation. We play golf tomorrow, you know. No problem.
Thank you.
Are there any more questions or comments? Well, before we break up, I promised that we would meet all these people, especially the Cass County people, and I'd like to. We've called these people First Amendment advocates, and we've called these people First Amendment heroes, and now the Greenlee School would like to officially call them champions of the First Amendment. And we have, which is obviously that may not be the best part of it. The best part is you get a t-shirt like this. But is Peggy is the one who she's not here. Okay, but we want to also make sure that everybody knows Peggy Rowland is not here, but she is one of the Cass County 7. James R. Tyler, would you come up and?
All of that contingent liability for a t-shirt is black.
We have the sizes and all this, and they're all right. You may have to switch them later. But if you get the wrong size, you really need to. Where's Dwayne? Okay. Triple H. Blame Dwayne because he's the one that gave your sizes away. So. Dwayne Acker.